Assalamualaikum and hi everyone. I am Tengku binti Tuan Saleh from Group 3 and my metric number is 053984. So, we are from Group 3 and we will be presenting on the topics of double jeopardy and the exceptions. So, we consist of 6 members which are Mursyidah, Nur Aqillah, Dinie, Nur Fathiah, Husnina, Ayra and me myself. So, let's proceed to the next slide. Now, we are going to be discussing the introduction part first. So, moving on to our first subtopic, which is the introduction. So, Article 7, Clause 2 in the Federal Constitution provides that a person who has been acquitted or convicted of an offence shall not be tried for the same offence except where the conviction or acquittal has been quashed and a retrial ordered by a court superior to that which he was acquitted or convicted. So basically, the Federal Constitution protects an offender from double jeopardy in a sense that an offender who has served his sentence will become a free man and assumes once again the status of innocent until proven guilty. No doubts shall be cast upon him once he returns to the society as a free man again for a second chance. Also, Section 303 of the Criminal Procedure Code contain similar rule from this article. Next, this is very much a basic guarantee to all people, and it doesn't matter if you are guilty or innocent. So this means as long as the court has decided on your case, you can't be prosecuted for the same offence again. However, some condition might reopen a case even after decision has been reached. This means that no one should be jeopardized by further criminal charges if he has already served his sentence and found guilty. Similarly, an acquittal is a permanent impediment to a second trial for the same offence based on the same circumstances. However, there are certain factors that can reopen a case although a decision has been made, which are the exception on the next slide. Now, let's go to the 4 exceptions of double jeopardy, which are discharge. The second one are quashing of earlier trial. The third one is technical errors, and the fourth one is different offence.
Assalamualaikum, my name is Husnina Ayra and I will elaborate on one of the exceptions of double jeopardy, which is a discharge. Discharge does not amount to an acquittal called as DNAA. DNAA means an accused be hauled back to the court for retrial, whereby DAA, discharge amounting to an acquittal, means an accused is acquitted of the crimes he allegedly commits. A discharge results in discontinuation of the trial for a variety of reasons, be it the court's lack of jurisdiction, absence of witness, and the prosecution refused to continue the charge. Oftenly, it was ordered because there might be insufficient evidence against the accused and the prosecution needs more time to collect the evidence. Secondly, the investigation against the accused is incomplete. And lastly, the prosecution will need more time to ensure that the justice is meted out according to the prescribed law. Therefore, the power of discharge and accused are on the burden of the court, the prosecution, and the prosecuting officer. As for instance, most of us would be familiar with the 1MDB scandal involving the former Prime Minister Najib Razak. As the key suspect of the scandal is still going through trial. However, his stepson Rizal Aziz has been making the headlines. Rizal Aziz was recently discharged from his 5 charges of laundering money from the 1MDB fund. The court gave Rizal what is called DNA, but the deal came with string attached. He needs to pay an agreed amount or to be granted the decision. As an outcome from the case, we can see the power of PP to halt the trial, wherein the prosecutor used the right to start prosecuting the accused mid-trial as provided by Section 254 of the Criminal Procedure Code. Therefore, the PP has halted the trials. The accused won't be granted a verdict upon the crime. Henceforth, he he is freed from the accusation but were considered not yet been tried upon discharge. Thus, to conclude, under this exception, someone can be re-accused to the same charge since the first charge were dropped.
Hello, Assalamualaikum. My name is Nur and I will continue this presentation by presenting the second exception for double jeopardy, namely quashing of earlier trial. As we know, Superior Court has the power and jurisdiction to quash previous trial and order a retrial. This decision of nullifying the decision of the lower court are based on the incompetency of the lower court or as may be because of the wrongful decision made in previous court. When a decision of the lower court is declared null, a retrial does not amount to double jeopardy, even if the public prosecutor used the same facts or even the same conviction to the accused person. To understand this exception, let's refer to a Malaysian case of South Soo Kim against public prosecutor in 1975. In this case, the material facts for the question of double jeopardy is that South Soo Kim, the appellant, and Tan Soo Ha, the co-accused, were jointly charged in the High Court in Ipoh. The appellant was acquitted while the co-accused was convicted. After that, the co-accused, Tan Soo Ha, appealed the case to the federal court and the court declared his trial was nullity. A retrial was conducted and both appellant and co-accused were separately tried and convicted under Section 4 of the Firearms Increased Penalties Act 1971 for the co-accused and under Section 307 of the Penal Code and Section 3 Clause 1 of the Arms Act 1960 for the appellant. There are two legal issues arise. Firstly, whether the acquittal of the appellant is null too, because only co-accused appealed the case to the court. Secondly, whether the retrial amount to double jeopardy. So, the verdict is court ordered that the appeal be dismissed. The acquittal of the appellant has been quashed and the retrial does not amount to double jeopardy. I hope everyone is clear about this exception. Then I will pass the floor to the next presenter. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nurul Aqillah binti Mahadi. So, I will be presenting the third exception to the rule of double jeopardy, which is technical errors. If the detention order was wrongly made out, or if the law authorizing detention did not apply to the detainee may be released. In this case, Datuk James Wong was arrested by several police officers from KL at his Kuching home on October 30, 1974. He was informed by the police that he was arrested pursuant to Regulation 7 Clause 1 of the Preservation of Public Security Regulation of PPSR. The High Court in Borneo issued a writ of habeas corpus for the release of Datuk James Wong on the ground that his detention under PPSR was unlawful, but this release did not bar a subsequent detention which is properly made out under the correct law.
Assalamualaikum warahmatullahi wabarakatuh. My name is Mursyidah binti Luqman Hakim and my metric number is 053073. I will be talking about the fourth exception to the rule of double jeopardy, which is different offences. Under the exception of different offence, what we need to understand is that if in the subsequent trial the accused is charged with different offence on the same set of facts, there is no violation of the Constitution. If the accused could not have been convicted with or charged with the different offence in the same court which convicted him first. So this exception can be further understood under the case of Jamali Adnan. What happened in this case is that the appellant was arrested and the police found 2 revolvers and ammunition in his place. He was then charged under the Penal Code for 4 counts of robbery with deadly weapon, which amount to 6 years imprisonment and 5 strokes of canes. Later on, he was charged under the Internal Security Act with the possession of 2 revolvers and 29 rounds of ammunition. Under this charge, he was sentenced to death. In this case, the Supreme Court of Malaysia held that the definition of same offence provided under Section 7 Clause 2 of the Federal Constitution can be defined as same in terms of the ingredients of the offence. Hence, under this case, where the accused were charged with 2 offences, which is one under the Penal Code and the other one under the Internal Security Act, both essential ingredients were not the same. Hence, this case falls under the exception of the rule of double jeopardy, which is different offence, which means he can be charged with the 2 offences as the ingredients were not the same.
So, in conclusion,
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh, and hi everyone. My name is Nur Fathiah binti Muhammad Nizam. My metric number is 053092. Before I go further, let me thank previous presenter for your excellent presentation. Alright, now I will conclude our discussion regarding double jeopardy. In certain circumstances, as mentioned by my friends before, there is a need for the court to decide the case based on the same facts and the same offence. This is because the court's function is to uphold justice as well as to deliver justice. It is now clear that, based on the case laws mentioned by my colleagues, double jeopardy is subjected to certain exception which is permitted under the law. Alright, I think that's all from us. Thank you for listening to our presentation. Assalamualaikum and stay safe everyone.